What if you pass without a will? What happens? If you pass away with no will in place, there is state law to fill in the gaps. If you haven't clarified in a will who your heirs and beneficiaries are, state law will dictate who gets what. State law tends to follow kind of what you might expect most people to choose, but not always. A surviving spouse is the primary heir and then children after that. If there are no spouse or children living, then it goes to your parents who would receive your estate. And then ultimately your siblings and nieces and nephews until someone is available to receive your assets. But it can get a little tricky. If you have a blended family or either of you or the surviving spouse have children from a different relationship, in this case, the numbers don't just go flat out 100% or in equal shares. So even though Florida law helps fill in the gaps to make sure that people who are close to you receive a share, it might be different from what you would want. And it also doesn't clarify who's in charge of the assets left to a minor or an incapacitated beneficiary. So state law really just follows the family tree, but really doesn't do a whole lot more to make sure that those who do receive your estate receive it in a way that you would want, and maybe at specific ages along the way that you would want. So if you die without a will, state law fills in the gaps. That is why it's really important to make sure that the plan you want is laid out in writing.